Criminal law and procedure, homicide crimes. Murder, intentional killings. A mercy killing is murder because it is an intentional killing, even if the victim asks the person to kill him. A person who sets up a mechanical device which kills a person, is guilty of the crime which would have been committed, if the person had personally set off the device intentionally. If a person takes steps to make substantially certain that an event will occur, he has intended the act, even if he subjectively does not desire that the result occur. Murder, intent to do great bodily harm. If a person commits an act which would not ordinarily inflict fatal injury, but would likely cause great bodily harm, and the victim dies, that person is guilty of murder, even if the victim died because of a peculiar medical condition. An intent to do great bodily harm can be inferred from the use of a weapon to inflict bodily injury. Felony murder. A defendant is not guilty of felony murder, unless he is guilty of the commission or attempted commission of the underlying felony. A defendant is not guilty of felony murder, if the commission of the felony has not yet begun, or is completed at the time the death occurs. A co-conspirator of the felon who actually commits the killing, is not guilty of felony murder, if the killing was beyond the scope of the conspiracy. The felonies of manslaughter or assault and battery cannot be the underlying felony for felony murder. If a third party kills a co-felon in the course of a felony, the surviving felon is not guilty of felony murder, because the killing is justifiable homicide. Abandoned or malignant heart murder. Firing bullets in a confined space or through a wall, or playing Russian roulette, is abandoned heart murder if a death results. Deliberately and unjustifiably driving a car onto a crowded sidewalk would constitute abandoned heart murder if a death results. Degrees of murder. A homicide accompanied by malice in the form of a deliberate intentional killing is first-degree murder. A death in the course of the serious common law felonies of mayhem, rape, sodomy, burglary, arson, kidnapping, escape, and robbery is first-degree murder, felony murder. A murder accompanied by malice in the form of intent to do great bodily harm is usually second-degree murder. A murder accompanied by malice in the form of a depraved heart is second-degree murder. Voluntary manslaughter. To reduce a murder crime to voluntary manslaughter, there must be adequate provocation to inflame a reasonable person into the heat of passion, and the defendant must have actually been in such a state. A violent battery, spousal adultery, mutual affray, and an illegal arrest are adequate provocation. The killing, must also take place in a time frame where the passions of a reasonable person would not have cooled, and the passion of the defendant must not in fact have cooled. A murder crime can be reduced to manslaughter, if the defendant had a defense, for example, a right to defend himself or another, but used that defense imperfectly, for example, by employing excessive force. If the defendant would only have been guilty of voluntary manslaughter if she had killed A, she is only guilty of voluntary manslaughter if she shoots at A, misses him, and kills V. Involuntary manslaughter. A death occurring in the course of willful, wanton conduct is involuntary manslaughter. A death occurring in the course of a misdemeanor malum in se, is involuntary manslaughter. A person under a duty to aid another person, because of a contractual or family relationship, is guilty of involuntary manslaughter if a death occurs because of unreasonable failure to give that aid. However, a person under no duty can unreasonably refuse to give aid without any criminal liability. Self-defense and defense of others. An aggressor does not have the right of self-defense, unless he attacked with non-deadly force, and is met with deadly force, or unless he completely ends his aggression, and makes that known to the person attacked. A person committing a felony does not have the right of self-defense. An individual has the right to use deadly force to apprehend a felon committing a dangerous felony, or to prevent a dangerous felony from being committed. Only non-deadly force can be used if the crime is a misdemeanor. Force is classified as deadly, or non-deadly, by its likelihood to cause death, not whether death in fact occurred. A belief that the person defended has the right of self-defense, is a defense in a criminal prosecution, even if the person defended does not in fact have the right of self-defense, for example, because he was the aggressor. To avoid liability and tort, though, the person defended must have actually had a right to self-defense. A person does not have the right to use self-defense to avoid being arrested by a police officer. If an individual has a perfect right of self-defense but, in the exercise of that right, kills the wrong person, the homicide is still excused. Other defenses to homicide crimes. Defense of property is not sufficient to justify the use of deadly force. A killing commanded by the law, such as an execution, or killing on the battlefield in time of war is not murder, because it is a justifiable homicide. Duress relates to coercion by a human force, whereas necessity relates to coercion by non-human elements. Duress and necessity cannot be defenses to a homicide crime, but can be defenses to an underlying felony, which would then be a defense to felony murder. Other crimes. Larceny. The specific intent necessary for larceny is not present, if the defendant intends to return the property at the time he committed the trespassory taking. If the defendant intended to return the property, the fact that it was not returned because it was unintentionally destroyed, does not transform the intent into an intent to steal. However, an intent to destroy is equivalent to an intent to steal. If possession is obtained by fraud, the crime is larceny by trick, not embezzlement. The trespassory act necessary for larceny can be committed by an innocent agent of the defendant. A person with title to property can be guilty of larceny, if he wrongfully takes that property from a person rightfully in possession. A lower-level employee in possession of the goods of an employer, or a bailee who breaks the bulk of the goods bailed, does not have a sufficient possessory interest to have the taking of those goods constitute embezzlement. Embezzlement. Embezzlement only occurs when a person rightfully gains possession of another's property, and then converts it to his own use. Obtaining property by false pretenses. To be guilty of obtaining property by false pretenses, the victim must give up title to property, in reliance on a false representation of material fact by the defendant. The defendant's honest belief that the representation is true, prevents the defendant from having the specific intent necessary for the crime of obtaining property by false pretenses, even if the belief is unreasonable. Receiving stolen goods. A belief that the goods were not stolen, is a defense to the crime of receiving stolen goods. If the goods are not in fact stolen goods, the defendant cannot be convicted of receiving stolen goods, even if he believes that the goods are stolen. Robbery. Larceny is an essential element of, and merges into the more serious crime of, robbery when all of the elements of robbery are found. The battery which constitutes the force employed in a robbery, merges into the more serious crime of robbery. The use of force or intimidation to retain possession of property already stolen is not robbery. The threat to use force in the future is the threat necessary for extortion, not robbery. Burglary. In order to be guilty of burglary, the defendant must have the specific intent to commit a felony, on the premises at the moment of the entering. Burglary is committed if the defendant breaks and enters a part of a dwelling house, even if he does not break and enter when he first enters the dwelling. The breaking and entering need not occur simultaneously. The breaking and entering necessary for burglary are present if entry is obtained by fraud. A person cannot be guilty of burglary for breaking and entering into his own home. Defendant is guilty of burglary, even if not successful in completing the intended felony. Assault and battery. The defendant never has the obligation to retreat, if he is using non-deadly force as a defense to an assault or battery. Rape. Consent to intercourse is not a defense if the victim's assent to the act performed is procured through fraud, which obscures the fact that intercourse is taking place. An underage female who engages in intercourse cannot be held guilty of conspiracy to commit statutory rape, or as an accessory to statutory rape. Kidnapping and arson. Demand for a ransom is not an element of simple kidnapping. A person cannot be guilty of the common law crime of arson for burning his own house. A minimal burning of part of the dwelling house is all that is required for arson, but the burning of the contents alone is not sufficient. Inchoate crimes. Attempts. To be guilty of the crime of attempt, the defendant must intend to commit the crime which she is attempting. If the act which the defendant intended to accomplish is not a crime, the defendant is not guilty of an attempt, even if he thinks he has committed a crime. If the defendant is successful in his attempt, and commits the substantive crime, there is no separate crime of attempt, the attempt and the crime merge. Conspiracy. A co-conspirator is guilty of the substantive crimes committed by any other co-conspirator during the course of the conspiracy, and within the scope of the conspiracy. If a co-conspirator withdraws from the conspiracy, and informs his co-conspirators of the withdrawal, he is not guilty of the substantive crimes committed by the conspirators after the withdrawal, but is guilty of the conspiracy crime. An overt act is not necessary to complete the conspiracy crime at common law, but is required today for federal conspiracy crimes, and is required in some states. The impossibility of accomplishing the object of the conspiracy is not a defense to conspiracy, but there is no conspiracy, if the parties mistakenly believe that the lawful object of the conspiracy is a crime. A person is not a conspirator unless he combines with another human being to commit an unlawful act, or a lawful act by unlawful means. Persons who do not have the requisite intent to qualify as a conspirator do not count as that other person. A person is not a conspirator if he does not intend to combine to commit a crime. For example, a person is not a conspirator if he intends to combine only to do something which he believes is legal. A person is not guilty of conspiracy if he combines with another person who is essential to the commission of the substantive crime, for example, adultery. Conspiracy does not merge into the substantive offense. Solicitation. If the party solicited agrees to commit the crime, there is a conspiracy, and the crime of solicitation is merged into it. Parties to crimes. To be guilty as an accomplice, the person must know that the principal is committing a crime, and must intend to help the principal. If the act being committed by the principal is not in fact a crime, the accessory is not guilty, despite his intent to help with an illegal act. Presence at the scene of the crime, plus encouragement of the principal to commit the crime is sufficient for accomplice liability. General principles. General intent crimes. To be guilty of a general intent crime, the intent to accomplish the act must coincide with the doing of the act. If a person desires a result, and that result occurs, even through an unexpected means, the person has intended the act for purposes of the criminal law. Specific intent crimes. To be guilty of a specific intent crime, the defendant must have the required specific intent at the time he is accomplishing the specific act. Strict liability. The doing of the actus reus is all that is required for the defendant to be guilty of a strict liability crime. Specifically forbidding an agent to perform an illegal act is not a defense for a principal, if performing that act constitutes a strict liability offense. To be guilty of an attempt to commit a strict liability offense, the defendant must have the specific intent to commit the offense. Mistake of fact. A reasonable mistake of fact is a defense to a general intent crime. A reasonable or unreasonable mistake of fact which prevents the specific intent from being formed, is a valid defense to a specific intent crime. Mistake of law. A mistake of law is not a defense to a general intent crime, but a mistake of law which prevents the specific intent from being formed, is a defense to a specific intent crime. Insanity. A mental illness which causes delusions will not create the defense of insanity under the Mitton test, if the individual knows what he is doing, and knows that it is a crime. The irresistible impulse test is not part of the Mitton test of insanity. Intoxication. In a specific intent crime, intoxication is a defense, if the intoxication prevents the defendant from forming the required specific intent. Intoxication can prevent the formation of the malice necessary to constitute first-degree murder, and reduce the crime to second-degree murder, but not to manslaughter. Causation. If a person mortally wounds a victim, but death occurs from a totally independent cause, that person is not guilty of murder. Improper medical treatment resulting in death is within the scope of the risk when an individual causes bodily harm. Therefore, lack of causation is not a defense to a homicide crime, if there was the required intent or misconduct. Justification. A police officer is justified in using deadly force to apprehend a person, who it reasonably appears is either committing or escaping from a dangerous felony. The use of deadly force to arrest a person for a non-dangerous felony, or any misdemeanor is not justified. A person assisting a police officer is justified in using the same force that a police officer would be justified in using. Constitutional protections. Arrest. Except in the case of hot pursuit, a warrant is required to arrest an individual in his home. A police officer has the right to arrest without a warrant outside of the home, if he has probable cause to believe that the arrestee committed a misdemeanor, in the presence of the officer or committed a felony. Definition of a search. A search involves government intrusion into space or activities, where an individual has a reasonable expectation of privacy. An individual has a reasonable expectation of privacy in his person, his home, including the curtilage, in his desk, and file cabinets in a private office at work, and in containers for personal effects. An individual only has standing to object to searches which violate his own reasonable expectation of privacy. The Fourth Amendment rules apply only to searches by government authorities, or those acting under their express direction. It does not apply to searches by private individuals. An individual does not have a reasonable expectation of privacy in his financial records in the hands of a third party. If property is in plain view from a place where a law enforcement officer has a lawful right to be, there is no search. Search incident to a valid arrest. If the arrest is invalid, or the search is made before there is a valid ground to arrest, then the evidence obtained by the search is inadmissible. A search incident to an arrest must be essentially contemporaneous with the arrest, and only of the area within the arrestee's immediate control. Consent searches. The consent given by an individual to search his own property must be voluntary, but the suspect need not be warned that he need not give consent. A third party can give valid consent to search areas over which he has joint access. A hotel manager cannot validly consent to the search of rooms in the hotel which are rented to guests. Automobile searches. The random stopping of automobiles without any probable cause constitutes an invalid search. However, stops of all vehicles at a fixed checkpoint are permissible. Once an automobile is stopped with probable cause, the entire automobile, including the trunk and containers in the automobile, may be searched. The search need not take place immediately. The police may stop a car and search containers within the car, if they have probable cause as to the containers. Other warrantless searches. A search at a border, or the functional equivalent thereof, does not require probable cause or a warrant. A regulatory search does not require probable cause. A stop and frisk is permitted only if there is a suspicion of criminality, and may extend only to a pat-down search. If the pat-down uncovers an object which may be a weapon, an intrusive search may be made for weapons. Searches pursuant to a search warrant. A search warrant can only be issued by a neutral and detached magistrate on the basis of probable cause. Probable cause can be based on the totality of the circumstances, and does not require evidence on both the basis for the search, and the reliability of the informant. The warrant must state with particularity the place to be searched, and the objects of the search. If a magistrate grants a search warrant, and the police execute it believing in good faith that it is valid, the property seized pursuant to the search is admissible. Coerced confessions. If a confession is coerced, even by a private individual, then it is inadmissible for any purpose. However, if improperly admitted, such admission is subject to the harmless error rule. Miranda. Miranda only applies when the suspect is interrogated while he is in custody. Interrogation can take the form of behavior by the police likely to induce the defendant to make a statement. If the defendant exercises his Miranda rights by demanding a lawyer, no further questioning can take place until a lawyer is present, and the defendant agrees to interrogation after consultation with his lawyer. If a defendant agrees to submit to interrogation, he can be questioned about more subjects than the crime, which is the primary object of the police interrogation. If evidence is inadmissible substantively because of a Miranda violation, it is nevertheless admissible to impeach. Lineups and other forms of identification. There is a right to counsel at a lineup only after the criminal process has commenced. If the likelihood of a proper identification is so remote, or the lineup is so prejudicial that it offends due process standards, then both testimony about the lineup identification, and a subsequent in-court identification are inadmissible. Right to counsel. A defendant has the right to counsel in all felonies and all misdemeanors for which he is actually incarcerated. An individual has the right to act as his own counsel and, if he does, he cannot later complain that he was denied his right to counsel. A defendant has the right to counsel for one appeal. The defendant has been deprived of effective assistance of counsel if his attorney has a conflict of interest, because he is also representing a co-defendant. Public trial, fair conduct by the prosecutor. Even if both the prosecutor and defendant want a private trial, the public has a right to a public trial. A trial must be public, unless there is either a substantial likelihood of prejudice to the defendant, or a need to limit access to ensure an orderly proceeding. A prosecutor has the obligation to disclose to the defendant all exculpatory material known to, or in the possession of the prosecutor's office. Jury trial, speedy trial. The right to speedy trial does not commence to run until the defendant is charged with the crime. The defendant is not denied the right to a speedy trial solely by the passage of time. There must also be prejudice to the defendant. The defendant is entitled to be tried by a jury if the period of incarceration can exceed 6 months. The defendant is entitled to be tried by a jury chosen from a venire in which there is no systematic racial exclusion. Neither the defendant, nor the prosecutor may systematically exclude individuals of one race from the jury by peremptory challenges. The jury need consist of only 6 persons. However, if the jury consists of only 6 persons, the verdict must be unanimous. If the jury consists of 12 persons, a 9-person verdict is constitutional. Confrontation, severance, standard of proof. The confrontation clause is satisfied if the defendant had the right to cross-examine the witness at a pretrial hearing, and there is a valid excuse for the witness's absence from the trial. If the statement of one defendant is admissible against the confessor, but also implicates a co-defendant, and is inadmissible against the co-defendant, the court must either excise the offending portions of the statement, or grant a severance. The prosecution must prove all elements of the offense beyond a reasonable doubt. However, the state can place upon the defendant the obligation to plead affirmative defenses, and prove them by a preponderance of the evidence. Fair trial, post-trial stage. The appellate court may constitutionally order a new trial, if the verdict is against the weight of the evidence. A defendant's criminal record is admissible after the verdict, for purposes of deciding the appropriate sentence. Double jeopardy. Jeopardy attaches in a criminal jury trial when the jury is sworn, and in a jury-waived trial, when the first witness begins to testify. Double jeopardy does not apply when the judge declares a mistrial to benefit the defendant, or the appellate court orders a new trial as the result of the defendant's appeal. The prosecution can only appeal a judgment, if a victory for the prosecution will not result in a retrial. Collateral estoppel. If issues are litigated in one criminal case between the prosecution and the defendant, they cannot be relitigated in a separate criminal case between the same parties.